Okay. So as I've mentioned before, I used to read to Uncle John all the time. Anything I was writing, working on, whatever, I'd read. And then we'd discuss it. Right? And then I'd do whatever, and then I would read it again, and he'd sit and he'd listen. So I would think that over the years, that really helped me to be a very good writer. But again, I'm the type of person where people, because I'm small and I'm petite and I'm poor, and I don't have my criminal crew beside me, you know, they just kind of blow me off like I'm a nothing, right? And they don't take me serious. And they try and make it like I'm really stupid, right? So I wasn't going to read this to you initially, but since I have to rewrite it again, because it's 7 pages, this is my appeal. That's supposed to go in front of 3 judges. And of course, you know, Fraser Health will come in with their reasons why it shouldn't go to trial, right? Well, you can see. They're full pages. That's the last page. It's almost towards the end. So 7 full pages. Do you see that? And I have to bring them down to half. I have to bring them down to 3.5 pages. So there we go again, watering everything down. You got to spit it out as fast as you can, just so that they can say not good enough, because they don't allow 7 pages. They only allow 3.5. So I'm going to read this. I'm going to read it halfway through anyway, since I have to rewrite it. This appeal is based on various provincial acts, regulations, and sections under the Criminal Code of Canada that are to protect the public from harm, misconduct, and from abuse of power by public servant employees who use their positions of employment to make decisions that do not meet the needs or expectations of the clients they serve. Additionally, due to the nature of the notice of civil claim and its complexity, where multiple provincial and federal laws were violated and completely disregarded for the benefit of Fraser Health Authority agents and their friends, a request is being made to the court to allow this matter to proceed to a trial in an effort to determine all the facts, where the burden of proof is determined without reasonable doubt that no federal crimes were committed to procure financial gains from Mr. John Duncan and his immediate family in the name of Chorney, for the benefit of FHA agents and their friends or corporate associates, as in the case of Canadian Imperial Bank of Commerce. Now, what is wrong with that paragraph? Absolutely nothing, people. 2, the plaintiff is the legal representative of Mr. Duncan and his affairs, while the duty of care to Mr. Duncan by Fraser Health Authority has been grossly negligent and misleading to the court. And even though FHA may continue to slander the plaintiff's character as defined under Section 298(1) and 319(1) of the Criminal Code of Canada, with inappropriate, okay? Continue to slander the plaintiff's character as defined under Section 298(1) and 319(1) of the Criminal Code of Canada, with inappropriate gestures that rely on case law to prove their point in an unsuitable trial setting to avoid having to answer to the court as to why they allowed their agents to release A, 76-year-old blind man with no ID on him and who suffers from physical handicaps right into the hands of strangers without the support of his immediate family of 23 years prior to Mr. Duncan disappearing on or about February 20th, 2015 from a FHA care facility in Surrey, BC. Under Section 34(1) of the Criminal Code of Canada, the plaintiff has every right to defend against unprovoked assaults against her persons and character, and including those against Mr. Duncan and any other member in Mr. Duncan's immediate family in the defense of the right to face the accuser or assailant, to whom is FHA and their agents, by means to either cover up what they did to Mr. Duncan and his family, or to protect others in their organization so that FAH agents can do it again to some other person. 3. FHA has not produced to the court any evidence confirming that their agents provided professional or proper health care to Mr. Duncan and his immediate family in a manner that can be cross-referenced and confirmed through various provincial regulations and mandates. On the contrary, the plaintiff alleges that FHA agents failed in their duties tending to preservation of life, as listed under the Criminal Code of Canada, Section 215(1). Hence, with respect to duty imposed by paragraph 1C, 1 and 2, FHA committed an offense under 2B that has injured permanently Mr. Duncan and his immediate family to such that the plaintiff is requesting the right to proceed to trial so that the duty of care provided by FHA to Mr. Duncan is simply not assumed to have not broken any federal laws, and therefore allowing the legal obligation of FHA, which lies on them, to go unnoticed, just as under Section 216 and 217(1, duty of persons undertaking acts dangerous to life, or duty of persons directing work. Fraser Health Authority has a legal duty to the court to confirm that the use of reasonable knowledge, skill, and care was provided to Mr. John Duncan when he was at their care facility before he suspiciously disappeared from it on or about February 20th, 2015. 4. Upon taking the responsibility for the plaintiff to represent Mr. Duncan and his immediate family, under this application to continue with the notice of claim filed against Fraser Health Authority and Canadian Imperial Bank of Commerce, the plaintiff has held legal enduring power of attorney regarding Mr. Duncan's general affairs, if there should be any, for a period of 25 years without any disruptions. In addition to, the court is asked to note that Mr. Duncan has an official active will that was written in the year of 1998, to which FHA agents illegally disregarded the enduring power of attorney and Mr. Duncan's will for the benefit of themselves and their friends. Hence, through the Hospital Act, under the title of Conflict of Interest Prohibited, it clearly states, Section 4(1)(2), an employee must not do any of the following. A. Persuade or induce or attempt to persuade or induce a patient to 1. Make or change a patient's will. 2. Make a gift. 3. Provide a benefit for an employee or the employee's spouse, relative, or friend. Or 4. Conduct the financial affairs of the patient for the benefit of an employee or the employee's spouse, relative, or friend. C. Act as a personal representative for a patient or former patient unless the employee is a child, parent, or spouse of the parent, patient, or former patient. 413. I can delete those things out and just add the numbers in, people, and hope that these judges go look them up in the acts. 413. A provision of a will, a change to a will, a gift, a provision of a benefit, or another measure described in subsection 2A1, 2, 4 is void if it confers a benefit to an employee or the employee's spouse, relative, or friend, and the public guardian and trustee has not given written consent to it. 414. If an employee acts as an attorney or as a representative contrary to subsection 2C, the power of attorney or representation agreement and any disposition made under the power of attorney or representation agreement is void unless the employee is a child, parent, or spouse of the patient or former patient. Well, let me tell you something. I put at least 90% of those people that were working in that care unit were all immigrants of some form. So none of them were the patient's spouse, parent, or child. They all came from different countries from all over the world, where the majority of them couldn't even speak or read, write English correctly. But yet they were the ones making the decision for John at the direction of the union. Because the union's only thinking about itself in terms of their pension plans and their superannuation life insurance policies. So they have to keep that money train going. So give that corrupt union worker a bone. Therefore, when applying the principle of the Community Care and Assisted Living Act under Section 18, 1, 3A, 1, 2, 3, 4, C, D, and 4AB, titled Certain Advertisement or Inducement Prohibited, for the time Mr. Duncan was temporarily housed at the Yale Road Center in addition to the Surrey Memorial Hospital, it was Fraser Health Authority and their agents who acted with bad faith through intimidation and malicious misconduct that demoralized Mr. Duncan and his immediate family in the name of Chorney, so that false pretenses, as listed under the Criminal Code of Canada, Section 3621, could allow FHA agents the ability to appoint themselves to be Mr. Duncan's power of attorney and or representative for the purpose to commit fraud and extortion, while Mr. Duncan and his immediate family were all under duress as FHA agents did so. Mr. Duncan, on many occasions over a period of 39 days, informed FHA agents to talk to the plaintiff about his medical circumstances and or regarding any financial inquiries. Consequently, when requested by Mr. Duncan or by the plaintiff to review Mr. Duncan's medical files, both he and the plaintiff were denied by FHA agents as they continued to accuse Mr. Duncan of being confused while in their care, and then began to accuse the plaintiff of elder abuse. FHA agents used accusations to their advantage and as their reasons to not allow Mr. Duncan to go home to his place of residence, where FHA agents would not come after him once leaving their care facility. As a reminder, under Section 32(1)A and B of the Power of Attorney Act, it is still the duty of Fraser Health Authority to provide the plaintiff, the attorney, to Mr. Duncan's legal and financial affairs with the requested information where the area of authority has been granted to the attorney by Mr. Duncan before he disappeared under questionable circumstances from a FHA care facility, and to which duty of care to the patient is still the responsibility of FHA. 5. That's 2 pages. In consideration to Section 7(1), A, B, 1, 2, C2, standards to be maintained under the Community Care and Assisted Living Act, it is the responsibility of Fraser Health Authority to ensure that their agents and various employees are persons of good character who meet the standards for employees specified in their regulations, in addition to operate the community care facility in a manner that promoted the health, safety, and dignity of Mr. Duncan, and including make his rights both orally and in writing known to him and to his legal representative while in the care of FHA. Consequently, FHA agents breached these basic legislated principles as they continued to retaliate spitefully against Mr. Duncan's representative, the plaintiff, to whom has had legal enduring power of attorney since October 30th, 1990. Hence, any matter regarding enduring power of attorney being revoked in any correct manner that would be considered legal has not occurred in any court of law or been done through the public guardian and trustee under the Adult Guardianship Act. Nor has any other application been put forward by a legitimate source through the Patient Property Act that could have lawfully removed the plaintiff from her position as the attorney and representative to Mr. John Duncan. In reference to Section 32, Immunity, Community Care and Assisted Living Act, 1, subject to subsection 2, this part I can remove, so we're going to just let that go. Well, I'll read it because I'm going to have to cut it out anyway. In reference to Section 32, Immunity, Community Care and Assisted Living Act, 1, subject to subsection 2, no legal proceedings for damages lies or may be commenced or maintained against the Director of Licensing, the Registrar, a medical health officer, or a member of the board or a person acting on behalf or under the direction of any of them because of anything done or admitted. 2, subsection 1 does not apply to a person referred to in that subsection in relation to anything done or admitted by that person in bad faith. 3, subsection 1 does not absolve the government or health authority or an employer from vicarious liability arising out of anything done or admitted by a person referred to in that subsection for which the government, health authority, or employer would be vicariously liable if this section were not in force. In reference to Section 33, Offense and Penalty, a person who contravenes Section 5, 6, 18, 2, or 3, or 26, 1 of this Act, and that Act would be considered the Community Care and Assisting Living Act, or a term or condition attached to a license, commits an offense. 2, a person who commits an offense under subsection 1 is liable to a fine of up to $10,000. 3, if an offense under subsection 1 is of a continuing nature, each day that the offense continues constitutes a separate offense. In conclusion, to Section 7, standards to be maintained under the Community Care and Assisted Living Act, Fraser Health Authority had a duty of care to provide Mr. Duncan and his legal representative, the plaintiff, Judy Chorney, a level of professionalism that was equal to the legislation that governs that duty of care. However, through convoluted acts from FHA agents to defame and slander the plaintiff under false accusations of elder abuse for the purpose to commit fraud on an employee level, where the unlawful seizure of the plaintiff's privilege as legal representative and enduring power of attorney was wrongfully removed from her by FHA agents without due process, clearly shows the negligence of Fraser Health Authority as a ruling body to their employees. It was the employees as a group who conspired to take over Mr. Duncan's asset at the expense of completely removing him from his immediate family via those convoluted occurrences that has brought this notice of civil claim forward. 6. If in FHA's defense, it has been said that Mr. Duncan was released from the Yale Road Center as if he was a fully functional adult male, to where Fraser Health Authority has absolved themselves from any responsibility as to what has happened to him or his immediate family in the name of Chorney since Mr. Duncan was released. However, FHA is not being forthright to the true nature around how Mr. Duncan was being illegally detained, as pain medications were being used against his persons as a restraint method to keep him wheelchair bound for the purpose so that mail fraud could occur in the effort to gain Mr. Duncan's banking information, as the plaintiff was being accused of elderly abuse by FHA agents to stall for time. FHA agents, contrary to their mandate, conspired with Mr. Duncan's extended family in Victoria, BC, to whom Mr. Duncan had no real relationship with except for him seeing his extended family members for a 1 to 2 day period when he would visit his mother for her annual birthday party. And it should be noted that as Mr. Duncan aged, he required assistance from his grandchildren within his immediate family to make that trip to and from Victoria each year, as he was legally blind and suffered from leg injuries in combination to back injuries from when he was younger. Therefore, it would have been medically negligent for FHA agents to discharge Mr. Duncan from their community care facility without ensuring that proper identification for off-site transfer of his persons was done in a manner that complied with the residential care regulations of the Community Care and Assisted Living Act. Under Section 58, release or removal of persons in care. 1. A licensee must ensure that a person in care is not A. released from the community care facility, 2, or B. removed from the care facility by any person except the person in care's parents or representative, or a person authorized in writing by that person. Subsection 1, 2, subsection 1 does not apply to the release or removal of a person in care in accordance with the care plan of the person in care or another pre-existing arrangement. Hence, under no circumstances would Mr. Duncan been able to write a letter authorizing any other person to be his representative for the purpose to remove him from the community care facility without having identification upon leaving the facility, or for him to refuse any follow-up on any medications that he had been receiving since coming into care of Fraser Health Authority. In addition to, if a third party drafted such a letter in writing and Mr. Duncan signed it, it would have been done under false pretense as listed under the Criminal Code of Canada, Section 3621 A, B, C, 1, 2, 4, 5, 6, due to Mr. Duncan's blindness, as he would have not been able to read what he was signing even if he wanted to. Therefore, Fraser Health Authority discharged a 76-year-old blind man who could barely walk without any personal identification on his persons, despite FHA agents having a vendetta to have Mr. Duncan go into convalescent care by any means necessary, designed by the FHA team within the first week of him being at the Surrey Memorial Hospital. Last paragraph, and I won't finish it, although I probably should. In response to Fraser Health Authority and their attempt to discredit the notice of claim filed against them when using the case law BD litigation guardian of V. Halton Regions Children's Aid Society, 2004, OJ number blah blah blah. The case law being applied does not relate to Mr. Duncan in the context of him being in the care of psychiatric doctors. The case number is number 6196. The case law being applied does not relate to Mr. Duncan in the context of him being in the care of psychiatric doctors due to being molested as a teenage girl. Nor did Mr. Duncan ever be diagnosed to be delusional or to suffer from any suicidal tendencies where he had been institutionalized for any period of time in his life. Therefore, FHA has attempted to misconstrue the facts pertaining to Mr. Duncan by introducing inappropriate suppositions against the character of the plaintiff to distract away from the allegations brought forth under the notice of claim. FHA is relying on the Mental Health Act as a shield to cover their reasonings as to how Mr. Duncan was discharged from their community care facility with only the clothes on his back and nothing more, because the doctor had a duty of care only to the patient, as Fraser Health Authority continues to protect the wrongdoings of their employees so that future misconduct can go unchecked and unfretted for scrupulous ends, for unscrupulous ends that do not meet the guidelines of duty of care under provincial law. However, if for any reason Mr. Duncan was being treated as a mental patient from the onset of being admitted into the Surrey Memorial Hospital and was being detained under the Mental Health Act, then Mr. Duncan himself was not told about that orally or in writing, and nor was his legal representative, the plaintiff, to which would be gross misconduct on Fraser Health Authority's part. Consequently, under the Patient Act, under Section 2.1, no application was put forward to the court by any person for the appointment of a committee to be assigned to Mr. Duncan, to which would have terminated the plaintiff's position of enduring power of attorney and her position of being Mr. Duncan's representative under Section 19A and B. In addition to Section 3.1 A, B, and C of the Adult Guardianship Act, no reasonable opportunity to respond was given to Mr. Duncan or to his representative, the plaintiff, if he had been appointed a statutory property guardian under this act before he disappeared on or about February 20th, 2015 from the Yale Road Centre in Surrey, BC, whereas to subject Section 3.2 A and B under this act based on allegations of elder abuse against the plaintiff by FHA agents, it is yet to be determined in a court of law whether those allegations are true and if Mr. Duncan was appointed a statutory property guardian because of those allegations. Anyway, I got 1, 2, 3, 4, 5. At least 6 more paragraphs that I don't know what I'm going to do with them, people. Like I said, they want everything watered down. Okay, people. So it's January 10th, I'm pretty sure, 2018. I've been kind of depressed for the last few days. So what I did is I made food for my kids. I made them, what is it called? Stuffed peppers with meatballs on the side and salad and that type of stuff. So my son had a huge big plate, like the good old days. Right? I used to cook a lot, people. So anyway, I've been just kind of thinking. I've been feeling kind of defeated. Right? We'll turn on this light a little more. Hold on a minute. If I don't wear my glasses, everything's blurry, right? As soon as I take off my glasses, I can see the bigger stuff, but things are getting pretty blurry. So anyway, like I said, I haven't been feeling that great. I was saying to my son, you know, I have these highs where I'm feeling really confident and, you know, I know what I'm talking about, right? It's pretty straightforward after you read those acts and you figure out what sections apply to you, right? Or your cause. And then there's, you know, other days when I'm just like, I'm feeling so defeated because the court system is skewed, right? It's not for the people. It's for the status quo. It's for the corporations. It's for that money train. It's for the rich to stay rich. It's not for the people. Because, you know, it's too easy for these lawyers to twist things around with unrelated court cases that completely distract away from the fact that Uncle John was more than likely removed out of their care facility in a hammock. under the influence of an opiate to pass him out so he didn't know what was going on with him. And that would have been on the 21st. Or 23rd. That would have happened on the 23rd of February of 2015 when I walked in. All right. And because I had Andre, people, I didn't want to be a drama queen and go running up to that hammock to see who was in it. But just in light that they had to take him to emergency, and he was there for a long time. And also, too, that they took him to a hospital that's known for giving shock therapy to the elderly, right? 86-year-old woman being scheduled in for shock therapy. Like, who does that? I mean, that's some really morbid crap. And all to make her forget the family that she wanted to be with because some other family decided that they owned her body and wanted her body. They didn't care about her mind. They just wanted the body. Kind of like what the Duncans did. They didn't care about John's mind. They just wanted the body. Well, these corporations, you know, they toss off that bone to these corrupt union employees that have seniority, that can educate the underclass within the union sector, and, you know, these people that contract out their services to go on the hunt for more victims. I mean, who wouldn't be depressed? Because these are very dangerous people. Like, extremely dangerous. What happened to John was completely morally wrong. And, like, I'm looking at 5 years of fighting corporations, if not longer. And I'm asking myself why. And I'm like, you know, I'm coming to the conclusion because I have a moral obligation. Because what happened to John was unfathomable. I mean, that's pre, you know, medieval times. That's something, that's like being on the stretcher with your body being stretched apart until you eventually just die. Or being crucified on a cross and then die. Or being locked up in a cage and poked at and starved to death until you die. With nobody rescuing you. That's the thing. Nobody is rescuing you. Everybody is just standing around watching. And this is what's happening with Uncle John. I'm noticing a lot of people are just standing around watching, and I'm asking myself why. Is it because a large majority of these people are wanting the money from their parents and their assets? Like my family, you know, my aunts and uncles couldn't wait to get my grandmother's money. Couldn't wait to get their sister's money, even though she had just died in the last 4 months. She wasn't even really gone that long, and they were scrapping over her money and telling my grandmother that grandchildren didn't count, to give my mother's share to them. Is this why a lot of people are staying silent on what's going on with Uncle John? Is because in the back of their mind, they know that their parents own houses and, you know, have saving plans and have life insurance policies, and they don't want to rock no boats because they think that because they're the son or they're the daughter, or I guess, you know, for some, they're the sister or the brother, you know, somehow that they're going to be able to push in front of that line and, you know, stand at that time and say, well, no, this person over here, his body belongs to me, or her body belongs to me. And forget about the mine, because, you know, there's assets there that I want, and I'm entitled to, you know, control those assets because that body over there belongs to me. Is that why people aren't stepping up the plate for Uncle John? You know, as I'm coming across them in my daily travels, is that why people are so passive about it in terms of, oh, well, you know, it's not my problem, or it won't happen to us, you know, we've got all our paperwork in order. I can pull out court cases, people, where people have had their paperwork in order, and if the public guardian and trustee wants to get involved and put their dirty fingers into that paperwork, they will do that. And then that family who thought that they had their paperwork in order will have to go to court against the public guardian and trustee to get their right back to have whatever authorities that they had before the public guardian and trustee got involved. I have court cases already like that. Because normally when they take people's assets away, they take it through the public guardian and trustee, and they do it through those various acts that I've been reading. The Mental Health Act, the Property Act, the Guardianship Act. Right? The Consent and Admission Form Act. That's 4 right there, written to take away people's assets on a provincial level. That all come into the public guardian and trustee, which is supposed to be an independent body outside of the government, receives limited funding because it's supposed to be at arm's length. But when you look at it as a whole, you can see that it's not at arm's length, because the people that have their assets taken, and there's quite a few of them people, end up in these long-term care homes to prop up that system. So that when the Legislative Assembly comes into debate, or whatever they do with their, yearly budgets and all this other crap, they'll sit up there and they'll say, oh yeah, well, we have 5,000 senior beds in the province of British Columbia, Canada. But they won't tell you that 2,000 of those beds, if not more, 2,000 for sure, that have been apprehended by the guardian and trustee, are paying for those beds, because the guardian and trustee will not apprehend poor people. They will not come in and help poor people. They are there to take over people who have somehow been deemed incapable through these acts, through various doctors and whatnot, and then the public guardian and trustee just comes in and takes over the assets to pay for medical services or whatever it is that they pay for in terms of taking their fees and everything else that they do. Right? And it's even written in these acts where, a person's pension, whoever has control of these assets, I don't know if they're obligated to spend up to, in other words, the patient is only allowed to keep $300 of their own money. Everything else goes into something else. I'd have to do more research on it. I've come across it a few times. I've seen people on Facebook and news articles complaining about that. Right? And it's written through the Community Assisted Living Act and the Pharmacare Act. Pharmacare? That act, anyway. So, like I said, I asked myself, what is wrong with people? Like, why are they so apathetic to Uncle John's story and our story in terms of a family and what's happened to us? Because our lives are in limbo, people. They will be in limbo forever unless this is solved. And, I'm thinking, probably a large majority are just thinking, one, it won't happen to them because they think they got their ducks in order, but little do they know. It doesn't take much to shoot down those ducks. Or they're secretly wishing to get their parents' assets when it's their parents' time to start liquidating. Right? However they liquidate. And those people just think that they're just going to, be first in line and, they're the firstborn son or, they're the smart daughter or whatever it is, everybody's got a reason to be first in line. They're going to get first dibs on, those assets, and therefore they don't want to get involved with what happened to Uncle John, because then they would have to morally check themselves. They'd have to ask themselves when they're parents, when it's their time, if they really love their parents and just, want to help their parents or whatever it is, or if they're only wanting their parents in the end for what they can get from their parents. I think that's a big one. I think that's a really big factor. Because we're so money driven in this society that, you know, it's really has brought us down to a lawless society. So as I'm thinking about this situation, you know, trying not to be depressed. You know, because I mean, I never planned to go to school to be a lawyer, people. I don't know how blind people that have pressure in their head and pressure in their eyes and, you know, their ears ringing and their body aches. I don't know of anyone that would want to go to law school under those conditions. But I'm being forced to become a lawyer, basically. And I'm trying to take it. I'm trying to take it like with a good attitude. There's another word I want to use, but I don't know what it is right now. You know, I want to take it with a good attitude. I don't want to see it as a bad thing. I want to see it as an empowering thing where, you know, after I've done my stint, wherever it takes me, I figure that, you know, I'll probably be able to help other people. Like, seriously. To the point where the people that I'm up against, if they don't like me now, they won't like me then. Right? Because I can only get better, people. Yes, I'll get more blind. You know, I'll probably feel like crap right up until I die. Whatever, you know. I've been coping with it now for quite a few years. I mean, I have my good days. I have my bad days, obviously, right? But, you know, you got to take that silver lining and you just got to develop it. You know, you make it a road of gold. You take the silver lining and you make it into a road of gold. You weave it into a road of gold. So, because I have a moral obligation, I have a moral duty. I have a moral duty to my family to protect them as their mother and grandparent. And I have a moral duty and obligation to Uncle John to try and protect him, even though the damage has been done. Right? To not let his suffering go in vain. Right? To protect the public from very dangerous people. Because if they did it to one person, they will do it again. Because they've been doing it, people. That's how they knew how to do it with John. They just thought I was dumb. And they did everything in their power to try and turn my life upside down and destroy it. So, now I'm thinking, well, maybe, you know, even though you're struggling with what you're working on, you don't want to add more to your plate. But I think it might be time to sit down and start writing some letters. To the CEO of CIBC Bank, for sure, in Toronto. If I don't hear back from this lawyer in a timely manner. I'm going to write, 4 or 5 or 6 at least MLAs in the province of British Columbia, Canada, where 2 or 3 of them I've met and John's met. Because I have been working on a nonprofit since 2000, people. And Uncle John came with me. I used to take him out with me to go meet local MLAs. As a matter of fact, we lived beside a local MLA. That's still an MLA. That's in Parliament now. That's in power. When I looked after that little girl for 3.5 years. She was our neighbor. She used to have little picnics in the field, in the school field, once a year, and we'd come out, and that's how she met John. And there was a couple times she'd have him in her office, and I'd bring my kids, and I brought John one time. And then there's another MLA we met and had a meeting with, discussing the nonprofit. So I think I'm going to write these MLAs, and I'm going to let them know of the terrorism that's going on, the homegrown terrorism, and I'm going to probably call it that, people. And being that I do have the police mandate, and I have the Dangerous Substance Act, that was back in the day with Sierra, right? That's when I got those acts, right? I still have them. You know, I'm going to probably look in them and isolate a few key points in reference to Uncle John, because what happened to him was homegrown terrorism. Okay? My younger daughter, just about 3 or 4 days ago, took my older daughter to the hospital to try and get her to get committed. They wouldn't commit her, people. And because she had burned her leg severely in some tent where they had a propane tank or something, I don't know. They ended up changing her dressing, but they wouldn't commit her. And then after they left, the doctor phoned my daughter and explained to my youngest daughter that Sierra goes in there quite regularly, right? If it's not for blood transfusions, it's for something else, right? And they know her, right? And apparently she can get quite aggressive sometimes because she's not feeling well. That's what it is, people. She's sick. She's like a caged animal that is being controlled. Like I said, who's pimping my daughter? Who benefits to have my daughter running around out in the streets doing the things that she does? Somebody's benefiting, right? So anyway, this doctor basically said that they wouldn't keep her because she can get up and walk away. That's what he said. She can get up and walk out of there. Nothing is holding her, like her legs. No, you know, she's able to get up and walk out, physically walk out. And because of that, she hasn't hit rock bottom, and she needs to hit rock bottom. She's already at rock bottom. She's been at rock bottom for a long time, people. It's just a poor excuse from the healthcare system that likes to operate on a two-tiered system as they bring in homegrown terrorism against those people with assets. And every now and then, they'll throw a bone to those corrupt union employees that know how to facilitate that money train through those acts that go directly into the one pot with the public guardian and trustee to take those funds and filter them back into the very system that those people disappeared into. Well, families are left to either, one, have a nervous breakdown and fall apart and disappear, and you never hear their stories because they're ashamed, or they're just, some of them maybe committed suicide, many of them have gone bankrupt, because it's not simply just take the body, it's also retaliate against the family that body came from. All you have to do is go into my videos. You'll see lots and lots and lots and lots of retaliation. Something that Fraser Health Authority doesn't care about, because their duty is to the patient. Even though they don't know what happened to a blind 76-year-old man that couldn't walk and had no ID after they released him to complete strangers. They just feel that they have no obligation to that. Hold on. Wait a minute. Hold on. So then I'm thinking, okay, so I think I'm going to start writing letters to some MLAs, some that we know, Uncle John and I both know, some that we don't. Obviously the Attorney General, the Minister of Health. I don't expect much results from the Minister of Health, just from the fact that I've written those types of people before. But the Attorney General, I would think that it might spark some interest. I really do. And the CEO, I'm not even going to waste my time. Just hold on a minute, people. Okay? And then I'm not going to waste my time with Fraser Health, with those board directors, because they're obviously in cahoots with these lawyers. They have too much to lose to be exposed, people. Okay? They are never going to admit to this. Because if they do admit to it, they're not going to be able to do it again. Let's just put it that way. And it's going to trickle out to the other health authorities. Because if one health authority is doing it, another health authority is doing it. Right? Because they're cousins to cousins to cousins. There's 6 of them in the province of British Columbia, Canada. And if they allowed Uncle John to be removed in a hammock all doped up so he could sleep like a baby on the ferry and then wake up and almost have a heart attack on the other side of the water, only to be rushed off to Victoria to be put in a hospital in an emergency setting as those people that took him are accusing me of abusing him, and that's how they found him. Are you listening to me? That's what they're telling those people. That's how we found him. Not that's how we found him in Fraser Health Care Facility. That's how we found him. That's why he has no ID. Because we went in and we rescued him from his house. So now we have to get some ID, and he's not allowed to talk to those people. There is no contact with those people because they've been abusing him. And those people in that hospital, they don't know anything. So, of course, they're going to believe what was fed to them, people. And the ones that did know, well, they obviously had an ulterior motive, because if you give the dog the bone, the dog is going to go out there and do what is commanded of that dog after it eats the bone. So I'm like, okay, I told my daughter tonight, well, we might be looking at a higher court here. We might have to go to a different court, like not to the Supreme Court, not to the provincial court, not to what is it called? An appeal court, although I will continue with that. But there's got to be a different court. So I'm going to start making inquiries what type of courts there are in terms of human rights. What, take it to the UN? Maybe. As I've said, in 5 years from now, I'll probably be a pretty damn good lawyer. I might be a blind one, but I'll still be a damn good lawyer. I'll be able to give people in this situation some damn good advice. Help to save lives, because that's the moral duty. My moral duty is to Uncle John to make sure that his suffering wasn't done in vain, that his immediate family suffering hasn't and isn't being done in vain. While we have mischievous court jesters that want to convolute the issues just so they can protect the corporation, so that they can do it again, because they have no moral obligation to anything other than a dollar bill. And they're stakeholders even though it's supposed to be a public service. Like, come on. So I'm being forced to go to school to become a lawyer. That's basically what's happening. Even though I'm sick and I'm not well, I'm being forced into it. Because I'm not going to drop the ball on Uncle John or my kids or my grandson. Or my fellow human being. How about that? From a moral perspective. All right. So a couple days ago, I was working on all that YouTube crap. Sorting it out. And it was kind of depressing. Right? But you can definitely see the timeline as to how the harassment was played out. Right? Again, something that Fraser Health doesn't want to acknowledge. Right? Because their obligation wasn't to the family. Once they took John out of the house and made sure he couldn't come home, they didn't care what happened to this place. But they didn't care what happened to John either. So, at least that's a level playing field. All right. So anyway, people, I will see you later.